Rules of Court, Civil Procedure, Rule 64, Review of Judgment and Final Orders or Resolutions of the Commission on Elections and the Commission on Audit. Section 1. Scope. This rule shall govern the review of judgment and final orders or resolutions of the Commission on Election and the Commission on Audit. Section 2. Mode of service. Mode of review. A judgment or final order or resolution of the COMELEC and the COA may be brought by the aggrieved party to the Supreme Court on certiorari under Rule 65, except as herein after provided. Section 3. Time to file petition. The petition shall be filed within 30 days from notice of the judgment or final order or resolution sought to be reviewed. The filing of a motion for new trial or reconsideration of said judgment or final order or resolution, if allowed under the procedural rules of the Commission concerned, shall interrupt the period herein fixed. If the motion is denied, the aggrieved party may file the petition within the remaining period, but which shall not be less than 5 days in any event, reckoned from notice of denial. Section 4. Docket and other lawful fees. Upon the filing of the petition, the petitioner shall pay to the clerk of court the docket and other lawful fees and deposit the amount of 500 pesos for costs. Section 5. Form and contents of petition. The petition shall be verified and filed in 18 legible copies. The petition shall name the aggrieved party as petitioner and shall join as respondents the commission concerned and the person or persons interested in sustaining the judgment, final order, or resolution ako. The petition shall state the facts with certainty, present clearly the issues involved, set forth the grounds and brief arguments relied upon for review, and pray for judgment, annulling or modifying the questioned judgment, final order or resolution. Findings of fact of the Commission supported by the substantial evidence shall be final and non-reviewable. The petition shall be accompanied by a clearly legible duplicate, original, or certified true copy of the judgment, final order, or resolution subject thereof, together with certified true copies of such material portions of the record as are referred to therein, and other documents relevant and pertinent thereto. The requisite number of copies of the petition shall contain plain copies of all documents attached to the original copy of said petition. The petition shall state the specific material dates showing that it was filed within the period fixed therein, and shall contain a sworn certification against forum shopping as provided in the third paragraph of Section 3, Rule 46. The petition shall further be accompanied by proof of service of a copy thereof on the commission concerned and on the adverse party, and of the timely payment of docket and other lawful fees. The failure of the petitioner to comply with any of the foregoing requirements shall be sufficient ground for the dismissal of the petition. Section 6. Order to comment. If the Supreme Court finds the petition sufficient in form and substance, it shall order the respondent to file their comments on the petition within 10 days from notice thereof. Otherwise, the court may dismiss the petition outright. The court may also dismiss the petition if it was filed manifestly for delay, or the question raised are too unsubstantial to warrant further proceeding. Section 7. Comments of respondents. The comments of the respondents shall be filed in 18 legible copies. The original shall be accompanied by certified true copies of such material portions of the record as are referred to therein, together with other supporting papers. The requisite number of copies of the comments shall contain plain copies of all documents attached to the original, and a copy thereof shall be served on the petitioner. No other pleading may be filed by any parties unless required or allowed by the court. Section 8. Effect of filing. The filing of a petition for certiorari shall not stay the execution of the judgment or final order or resolution sought to be reviewed, unless the Supreme Court shall direct otherwise, upon such terms as it may deem just. Section 9. Submission for decision. Unless the court sets the case for oral argument or requires the parties to submit memoranda, the case shall be deemed submitted for decision upon the filing of the comments on the petition or of such other pleadings or papers as may be required or allowed, or the expiration of the period to do so. Rule 6. Okay.